All right. United States Court of Appeals for Veterans Claims is now in session with the Honorable Mary J. Sherlin presiding. All those who have business before the court, draw near and you shall be heard. God bless the United States and this honorable court. Please be seated.
Morning. My name is Judge Sherlin. To my right is Judge Allen. To my left is Judge Toth. We're here today to hear the case of Sean P. Lacey v. Robert L. Wilkie, Secretary of Veterans Affairs, docket number 17-3296. With counsel for each party, please note your appearance order.
Good morning, Your Honors. Jennifer Zajac, Associate General Counsel for Paralyzed Veterans of America. With me today is Linda Blahu, Deputy General Counsel.
Good morning, Your Honors. Amanda Haddock appearing on behalf of the Secretary. With me at counsel table is Christopher Wallace, Deputy Chief Counsel.
Would the Appellant's counsel wish to reserve any time for rebuttal?
Yes, Your Honor. 10 minutes, please.
Thank you. And you may begin when ready.
Good morning, Your Honors, and may it please the Court. My name is Jennifer Zajac, and I am here today on behalf of U.S. Army veteran Sean P. Lacey. This case is about the actual language in the Vow to Hire Heroes Act of 2011, which created the Veterans Retraining Assistance Program, as opposed to the language that the Secretary wishes was there. Based on this actual language, or Mr. Lacey's reasonable interpretation thereof, Mr. Lacey requests that this Court do two things. First, that this Court reverse the Board's decision that Mr. Lacey's coursework at Medill College was not entitled to VRAP benefits, and second, that the Court order the Secretary to pay him for the 12-month worth of benefits that he is owed. So, how do we get there? As the Supreme Court, the Federal Circuit, and this Court just last week said, we start with the plain language of the statute. If that does not answer the question that the Court has today, then we can turn to canons of statutory interpretation, the purpose of the statute, and the legislative history. And if all of that doesn't get us there, then we look at the reasonable interpretation of this. We can kind of skip over Skidmore deference or any sort of deference. As the appellant pointed out in her brief, there's no legal interpretations that are binding here that the Secretary has put forth. And two, the Secretary did not address this issue in his brief and therefore has waived this argument. So, starting with the plain language of the statute. Mr. Lacey met the basic eligibility requirements for the program in that he was in between the ages of 35 and 60, was unemployed, was not entitled to TDIU, was not participating in the unemployment programs put forth by the state or the federal government. He then went on to pursue a program of education, in this case business administration, on a full-time basis in a program that was offered by a community college or technical school that led to an associate's degree or a certificate, or in this case, similar evidence of completion of the program. The program was designed for training of a high-demand occupation, in his case, a computer support specialist, in that his program work did take place after July 1st, 2012. Now, Mr. Lacey thinks that he has met all of these requirements and that the Court can just base it on this. The coursework.
Could I ask a question?
Of course, Your Honor.
So I think there's two ways that this question can go. So is there any limitation on your understanding of what would be geographically or temporally sufficient to show that courses were offered at a community college or technical school?
No, Your Honor, I don't believe there would be any geographic or temporal limit. The language is offered by a community college or technical school.
So does that pose any issue in terms of whether or not we should just accept the plain words of the statute? Because I'm with you, Congress didn't say enrolled, and it knows how to say enrolled because it did it lots of other places in educational statutes, and it chose the words it chose. But, so in theory, then somebody could find a course of study in Eastern Zimbabwe 25 years ago at a technical school and say, this qualifies even though it's never taught anywhere, even remotely where I could take it. And if that's right, then should that cause us some pause in saying that the language means exactly only what it says?
Well, Your Honor, I don't think it should cause pause, but the first part of your question, is that right? I think the language being in present tense is offered by a community college or technical school would mean that we are looking at the present tense situation, that the...
So then there is a temporal limit in your view. It has to be currently or at least close in time.
Yes, Your Honor, to correct my prior answer, yes. It would be a current offering of a community college or technical school at the same, temporally with the same time that the veteran actually took the courses. So if a veteran after the fact wanted to say, well, that was offered 5 years ago, and we would say, I guess in this instance, no, it needed to be offered at the same time because it's present tense.
And so the geography point is not a problem?
I don't think so, Your Honor. I think that the geography, if the coursework is offered by community college or technical schools in England or Zimbabwe, wherever the course may be, if the idea is to get these guys back into the workforce and working on things that are high demand jobs. So if they are offered at a community college or a technical school in another country or another part of the country from where they are actually located, but they are able to take coursework that still is under Chapter 36, because that's the other hook on here. It's not just any school that they're allowed to go to. The coursework that they're taking it at has to still be VA approved. It just also needs to be offered by one of these other type of schools.
Would there be any limitation as to the type of degree that could be offered? For example, if Mr. Lacey were pursuing completing a PhD in something, would that be anything that the statute would cover?
Yes, Your Honor, and that's is offered by language for community college or technical school. The PhD programs are not offered at community college or technical schools.
Well, neither is a Bachelor of Arts program offered at a community college or technical school.
You're right, Your Honor, but the broader program of just business administration is offered at community colleges.
PhD in business administration.
True, Your Honor. The idea behind this was to be getting veterans that had some sort of training and then moving forward with it to get them back into the workforce. So if you're looking at the broadest interpretation possible, would that possibly in another instance be allowed? Under Mr. Lacey's interpretation, yes, I think it would be.
I have some questions about your looking back to 3452 for guidance and how to interpret VRAP.
Yes, Your Honor.
Two questions. First, it seemed that in your arguments you seem to be looking at 3452C.
Okay.
However, VRAP specifically only mentions 3452B.
Yes, Your Honor.
So can you explain to me why we should look to C?
The C comes from the language within B. So within B, it talks about educational institutions, and then C defines educational institutions.
Okay. So then now the second part of my question relating to referring to 3452. If we look at B, it defines the program of education. It's a fairly broad definition. Any curriculum, it considers test prep, broad spectrum of things it could be. But we all agree that VRAP doesn't apply to any curriculum, right? Because the public law included certain limitations. It has to be a high demand field. It has to be a course that's offered at a technical institute. So why would we interpret it so broadly as you interpret B and C to apply in this test, in this program?
Well, I don't think that it's interpreting it so broadly. I think that the catch is that the coursework does need to be offered at a community college or technical school. And there are institutions and programs within those definitions that wouldn't meet that qualification. So, for example, elementary schools and high schools, and there's some other institutions that wouldn't be then offering the courses that a community college or technical school would be offering. So there is a narrowing. Those are educational institutions, Your Honor.
High school.
Yes, Your Honor.
I guess it's secondary school.
So you do have this kind of floor, and there are parts of the educational institution that they want to exclude. They want we can go into Congress's intent here. All we know is that they were trying to get gentlemen such as Mr. Lacey, who is unemployed, who were looking for retraining, were looking to clearly had something behind them to begin with, and you would think that gentlemen and ladies that are of that age group that are most likely have some sort of degree to begin with. So we're not looking to penalize these folks for the fact that they have that. We're looking to get them to a point where we can get them back into the workforce and giving them the opportunity to do this. And it's only 12 months worth of benefits. It wasn't any intention to actually cover the full degree. And the Undersecretary himself pointed that out in one of the committee hearings on this issue, that this was only 12 months, that most associate's degrees are actually for 2 years. And so if you're not going to be providing the full amount of the benefit to cover a full associate's degree, then, and the acknowledgement is there that it is just a short benefit, this is just supposed to give them an edge, get them back in, kind of put a carrot out there to say, hey, look, if you go back to school, we'll give you some money towards that. Not all of it. And mind you, this was never any intention to pay for everything. And it doesn't matter which school you're going to. We're going to pay you the same amount. Let's get these guys and girls back into the workforce. And this is the way to do it. So we have several canons of interpretation that also support this argument, the idea that we're giving effect to every word in the statute. The Secretary's interpretation either reads out the words or replaces them. And as we all know, that's not something that we can do unless the words themselves lead to an absurd result. Can't imagine that having a veteran go back and get his bachelor's degree in this instance would lead to such an absurd result.
I just had a quick question. I think this is a good place to ask it. I wanted to ask about the role of Gardner in your argument, right? And so I think it can be argued in a couple different ways. So one would be maybe in the alternative, which is that you have your canons, and you would say this is our best reading, maybe you should win under that. And in the alternative, if you find it ambiguous, here's Gardner. Right? So that's one possibility. The other is just to say Gardner is a canon among other canons, and here would be superior. Here would be the most on-point canon because none of the others really speak directly to this. And so I just want to get a sense of where Gardner would fit in your overall argument.
Here, and I think that you look at the canons of interpretation under the guise of Gardner. So you kind of have the idea that we're in a pro-veteran, we're in veterans benefits, which is remedial statutes, and all of that in behind you while you're looking through the canons of interpretation.
You would not necessarily find that the statute on some terms fundamentally ambiguous to invoke Gardner in this case. It could be sort of a guide, it could be a canon among other canons, sort of a super canon or something.
Well, Your Honor, if this court wanted to elevate it up to that, I don't think that that's happened previously. There's kind of been this ongoing back and forth between the court of where exactly do we put Gardner into this. Absolutely, Your Honor. And I think there was a case that I cited to in my brief that was Commonwealth of Massachusetts that wasn't talking about a veterans case, but was talking about a Native American law case. And in that instance, they were saying that when we're looking at the canons of interpretation and trying to decide whether there is ambiguity, because just because there's a difference in reading doesn't mean that there's true ambiguity, that we look at it always with the kind of glasses that we're looking, in that case, we're looking at it through Native American law, and Native American law, similar to veterans law, is supposed to be in favor of that population. And so here, if we're looking at it through the glasses, so if your canons of interpretation aren't totally on point, but we're looking at it, okay, can Gardner kind of push us over the edge on the canon of interpretation? It doesn't specifically put us there, but if we're looking at it and we're supposed to be taking these canons and getting to a pro-veteran stance, Gardner kind of puts its thumb down for us and says, yes, we can do it. If the court isn't comfortable with doing that, then you fall back to, after the canons of interpretation, if those still don't get us there, kind of looking at it without those glasses on, then we get, is it a reasonable interpretation? And Gardner and the Federal Circuit and Searcy say, if both sides kind of offer a reasonable interpretation, then we go with the veterans, because we're looking at a world where the veterans are supposed to come out on top here. We're supposed to be getting these guys back into the workforce. This was a, as I said earlier, carrot. This was something to help veterans in pursuing their benefits of getting jobs and getting some education behind them in order to do so.
Can I get your view on this, which is that the Secretary makes an argument well under subsection B3 of the statute, that is about the evidence of completion or something. Is it appropriate for us to address that argument? Because as I read it, I didn't think that the board discussed that, or at least it mentioned it in passing, but it certainly didn't go out of way down that.
Your Honor, since the Secretary acknowledged that in their brief, I think it would be appropriate for the court to address the Secretary's argument from a broader picture. I don't think the Secretary should have gone there from the standpoint of that's not what the board denied the claim on. The board only denied the claim on was the offered as a community college or technical school, and in fact, when the board made its decision, it didn't even use that language.
So, and I'm sure this is me, not you, that answer confused me, because the way you started, you said it's appropriate for us to consider it, but then you said you were surprised the secretary did this, but the board didn't talk about it. My question is, because the board didn't talk about it, is it appropriate for us to, let's assume that we read subsection B2 to say exactly as you say it should say. But then hypothetically, the secretary's argument could be phrased as, but it doesn't matter because we wouldn't win under subsection B3. Do you think that's appropriate for us to go and look at B3, whether it's on the secretary's basis or on the basis of our having to take into account of the rule of prejudicial error? Or should we say, listen, that's not the basis on which the board decided this at all and decline to go there? Which would you prefer us to do and why?
If I could actually offer an alternative, Your Honor, I think in not discussing it and specifically focusing just on the as offered by language, that the board, in a backhanded way, made the favorable finding that that part of this would be met. And so you could go down the Madrano line that this court can't touch the favorable findings of the board.
Well, that would be a hard sell. I mean, it's sort of a hard sell to say that the board determined that there would be sufficient evidence. At least that's my view.
I just thought I'd throw it out there.
So, assuming that you've lost one of us on that,
but the other two?
What would you say? Which one would you think we should do of the alternatives I think? We should just simply not discuss it, or discuss it and decide it on our own.
My standpoint is always to have the discussion out there. I think it helps veterans and the veteran law to have these discussions put forth in the decisions. And when I'm reading through a decision, and I personally get frustrated when I personally have briefed several issues and the court doesn't address all of them. So from my standpoint, especially since I think we have the winning argument on that, I think that it would make more sense for the court to address it, kind of explain why the secretary's opinion is incorrect on this issue, and then move forward with granting my client the benefit. At the end of the day, Mr. Lacey is here because the secretary took a very narrow reading of plain language that is offered by a community college or technical school. He met that. He provided the secretary proof of that his program of education was offered by a local community college in his area, and the board erred in finding that his coursework at Medill College was, yes, Your Honor.
If we find that it's not plain language, I know there was some back and forth regarding legislative history in the briefing, but when you look at the legislative history regarding H.R. 2433 that earlier introduced related bill, they specifically state the program was to allow veterans to enroll at community colleges and technical schools. How do we overcome that?
I think you overcome it by that it doesn't say that they can't enroll somewhere else. There wasn't any actual discussion on this particular point. There wasn't any discussion on this part of the statute at all. So if you're looking at that, that's part of it, that they can enroll at community college or technical schools, and Mr. Lacey doesn't agree with that, or doesn't disagree with that. Nobody says that that's not where it is.
So we would have to have Congress saying, and veterans will get the chance to not only enroll at community colleges, but also, or exclusively at community colleges for your viewpoint to change.
Well, I think they would have to have created a different purpose. They would have to have created a different purpose for the statute in order to focus just on that. And here the purpose was to get retraining, get guys and girls that have in this age group back into the workforce. They weren't there. And so if you're looking at this age group of 35 to 60, a majority of them would probably have some sort of degree to begin with. And so while it's great that they want to enroll at the community college or technical schools, there's no logical reason to not allow these particular people to also go where they need to be able to get back into the workforce. Mr. Lacey had an associate's degree. He knew that that was not enough for what he wanted to do, and I see that my time is out. Okay.
If I could interject, there's a limit on the number of people who could participate in this program, right?
Yes, Your Honor.
So let us assume that there were, whatever the cap was, 45,000 veterans who wanted to attend community college or technical programs, and Mr. Lacey made it one over the top. Would you have to choose between the two? Like, who would have the more righteous cause? How would you select?
I don't know that the applications were looked at that closely, Your Honor. I don't know that there's a matter of deciding between them. It would just be the numerical order of whose application was there first, since it's a cap. Thank you, Your Honors.
Good morning, Judge Sholin, Your Honors. May it please the Court. The Secretary maintains that the Court should affirm the August 2nd, 2017 Board decision on appeal. Section 211 of the Vow to Hire Heroes Act, or the Veterans Retraining Assistance Program, VRAP, is clear. In order to be eligible for benefits, a veteran must have been pursuing a program of education offered by a community college or technical school, and that program of education must have led to an associate's degree, certificate, or similar qualification. Subsections B1 through B5 of the VRAP legislation are criteria that must be met by the program of education, not criteria that the veteran himself must meet. As a result, it would not have made sense for Congress to use the term enrolled at rather than offered by a community college, because a program of education cannot be enrolled at a school. It can only offer such a program. Additionally, when applying the statutory definition of program of education to the facts of this case, Appellant's same program of education was not offered by a community college or technical school, and so was not eligible for VRAP benefits. A program of education includes a predetermined and identified educational objective. Predetermined educational objectives of community colleges and technical schools include associate's degrees, certificates, or similar qualifications, in some cases a vocational license. Appellant's predetermined educational objective at his program of education was a bachelor's degree. By that very nature, the same program was not offered at a community college or technical school. The Supreme Court, yes, Your Honor.
So I don't think there's much of a question that Congress intended these benefits to be used at community college. The question we're having is whether the statute that Congress actually drafted and passed would necessarily exclude a limit that's just for those narrow class, and where it couldn't just be read on its own sort of hyper architecturalist terms, include also colleges. What sort of exclusionary language would you point to in the statute that would say that this could not be extended out to colleges and universities?
Of course, Your Honor. We would point to the law's reference to 38 U.S.C. Section 3452B. As Judge Sholin noted earlier, Congress did not reference 3452C.
It seems to me that's a bit problematic because we use this that educational institution, and that language isn't being, it's defined by states, so that definition is incorporated. To me, I think the limit happens after that. That would be the sort of opening grant, and then the limitations are later in the statute. But I would see that as exclusionary language.
Yes, Your Honor. As the statute goes on to note, we argue that the language community college and technical school is that limiting language. Yes, Your Honor. Because Congress referred to 3452B, they then limited the program of education for the educational institution purposes to community colleges and technical schools. Had they intended veterans to be able to use this benefit at four-year universities or any other educational institution, they could have said so. But they did include the limit of community college and technical school.
So it's sort of like general and specific canon, something specific in a statute, not sure something general and specific is going to control. Is that sort of the argument that I'm hearing?
Yes, Your Honor. The Supreme Court has held that statutes must be read as a whole, since statutory language depends on its context. Here, focusing only on one subsection of the public law ignores this cardinal rule of statutory interpretation. A court cannot be guided by a single sentence or a member of a single sentence, but must look to the provisions of the entire law, as well as the policy behind that law. The policy behind VRAP was simple. Congress wanted to tackle the growing veteran unemployment rate by providing a limited education benefit to an underserved population of veterans, with the purpose of using this benefit at community colleges and technical schools with the aim of quickly entering the workforce in a high-demand occupational field. When read as a whole, Section 211 clearly relays this policy.
I can interject right there.
Yes.
Why doesn't allowing a veteran to attend whatever educational institution to allow them to get a job in the high-demand field within those 12 months achieve or fulfill that purpose?
Your Honor, it would achieve that purpose. However, we are stuck here with the language of the statute and Congress's intention that the benefit be used at community colleges and technical schools, which was a specific limitation placed on where the program of education must be offered.
Yes, but why wouldn't we then maybe so a couple of things. First of all, recently the Supreme Court decided the Kaiser case.
Yes.
And although that has to do with our deference, in Justice Katie's opinion for the court, in the importance that she had the majority, she talked about the fact that, courts need to decide whether there is genuine ambiguity in the statute.
Correct.
And here, it seems to me, if you read it, the veteran has submitted evidence that this program is offered by a community college or technical school, and not, according to my hypothetical, out in somewhere in the middle of Africa, but literally in Erie County, which is where he was in upstate New York. And that's broadly consistent with Congress's policy, as you've described it, to the extent we're going to check our plain reading with policy. And then when we go to where Judge Toth's question about the Gardner presumption, to the extent we're left with a doubt that pushes us in that way, why shouldn't we look at it in that way?
Yes, Your Honor. Well, we would argue that Gardner does not apply in this case. While generally Gardner does apply to veterans law and veterans law provisions, here there was, as noted earlier, there was a specific cap on the number of veterans who could receive this benefit. Letting one veteran lose means another veteran wins, which by its very nature is not necessarily veteran friendly.
What empirical basis do you have for what you just said?
So with regard to this specific legislation, Your Honor, the cap provided by Congress on the number of veterans, unique veterans who could receive this benefit, implicitly means that it's not widespread to benefit all veterans.
Well, no, I'm with you, but you're, and you may be right, but we have to make lots of assumptions to say, so we won't use the Gardner presumption, or the Gardner presumption doesn't work for the reason you gave, without you providing some empirical information, like how many people were subject to this benefit, right? Or apply. I mean, that was going to be my second question, which is, maybe the number of people who are applicable for the benefit is less than the cap. I doubt it is, but I have no reason to do other than guessing. And I don't know if you have statistics.
I do. I can provide those. So Out of the date that VRAP became effective, July 1st, 2012, over 126,000 veterans were approved for the benefit in that they were found eligible and received a certificate of eligibility. However, just over 76,000 actually enrolled in approved programs of education and received the benefit.
So into which group would Mr. Lacey fall?
He would fall into the 126,000 veterans who was eligible for the benefit, but then among about the 50,000 veterans who were approved but were not enrolled in a program of education.
And there were 94,000, and I went to law school, so I don't know math. Veterans who were allowed to participate over the 2 fiscal years of the program.
It was 99,000, Your Honor.
So there's veterans left on the table.
In theory, yes, there were remaining spots. However, the mechanisms to pay for this benefit no longer exist. They were expired at the time the VRAP benefit expired in 2014. Quite simply, appellant is not the type of veteran that VRAP was designed for. There's no indication in the record that prior to beginning at Medallier College, the veteran was unemployed. Rather, the record reflects that he was not receiving the types of job opportunities that he desired, and so he decided to pursue his bachelor's degree. He obtained his associate's degree in 1997 using his Chapter 30 Montgomery GI Bill benefits. The time he completed that degree, he still had another 9 months and 17 days of remaining entitlement that he did not use. As such, that entitlement expired in 1999, 10 years after his separation from service. He's pursuing his bachelor's degree in March of 2011, well before VRAP was passed into law. He did not go to school with the intention of receiving VRAP benefits or any VA benefits. When, like here, the terms of a statute are unambiguous, judicial inquiry is typically complete. However, a court can still look to the legislative history to determine if there is a clearly expressed legislative intent to the contrary. There is no legislative intent to the contrary shown here. In October of 2011, the House Veterans Affairs Committee issued a report on the legislation. The Supreme Court has held that a committee report represents the considered and collective understanding of the congressmen involved in drafting the proposed legislation.
Does it matter that a veteran intended to pursue an educational benefit from the VA when they started their educational program?
Not necessarily, Your Honor. And while we do acknowledge that the veteran had received Chapter 30 VA benefits, those benefits expired, which made him eligible for the VRAP benefit, which is why he obtained his certificate of eligibility. He had no remaining education benefits in which he was entitled to. So no.
The fact that he started college or returned to college before VRAP or before applying for VRAP isn't illegal.
Correct, Your Honor. His intention of whether he was intending to receive benefits is not particularly relevant to the statutory interpretation here.
I'd like to talk a little bit about the language about the leads to an associate degree or certificate or other similar evidence of completion of a program of education. Why is a bachelor's degree not a similar evidence of completion of the program of education?
While a bachelor's degree is certainly evidence of completion of a program of education, in this specific situation, it is not similar evidence to an associate's degree or a certificate showing completion of a program of education at a community college or technical school. Even when reviewing the veteran's own testimony, during his board hearing in May of 2015, as well as his decision review officer hearing at the regional office in February of 2015, bachelor's degrees and associate's degrees are not considered similar, which is evidenced by the fact that appellant decided to obtain his bachelor's degree because he was not offered the jobs he wanted with only an associate's degree. By his own admission, it can be inferred that these are not similar types of degrees.
I got two questions, but the first is that what would be an example of something that's in that similar quality to an associate's degree or a technical?
Yes, Your Honor.
Right. Because obviously they're different because, it's true that a bachelor's degree and an associate degree are different things. That's why the word similar could connect them.
With respect to the specific language in the statute, things like vocational licenses would be similar evidence of completion of a program of training or a program of education, which is actually one of the most common evidence of completion we have that veterans have obtained through VRAP.
So how about a situation in which you were at a school so for example, where I used to live in Florida, there was a place that was called St. Pete Junior College, and it was essentially a community college. Then they changed, it became St. Pete College, because they offered 4-year degrees. But as part of their history, they still kept lots of their time of being a community college. So assume you're at a place like that, so it's a 4-year college, but what you get is a professional license because you take a major that, their thing is, and you get a license to fill in the trade, okay?
Yeah.
You would still say, though, that doesn't count because even though you end up with a license that you could have gotten at a technical school, because they happen to offer a 4-year degree, they're automatically boxed out.
Yes, Your Honor, that is the parameters of the statute and the interpretation that is clearly read from the language.
But I mean, doesn't that seems to me far more absurd than Appellant's argument on this point. That seems sort of strange to me.
In response to VRAP, the Office of Education Service within the Veterans Benefits Association clarified the definition of community college. In order to qualify as a community college for the purposes of VRAP benefits, a school needed to be identified by the Department of Education as a 2-year institution. As such, any 4-year institution, even if they offered associate's degrees, licenses, certificates, would not qualify for VRAP benefits.
So what was this?
This was a internal procedural advisory issued by the Office of Education Service within the Department of Veterans Affairs.
Was that? I'm getting older by the second, and I don't remember reading anything about that in the briefing. Was that?
It was not. It was an internal memo that was obtained after. I apologize, Your Honor.
When was that issued?
Yes.
That was issued in June of 2011.
And so tell me the import, if any, of this thing that we're all hearing about for the first time, or at least those of us.
So this, again, was just an internal memo for how Education Service interpreted community college for the purposes of VRAP benefits in conjunction with the Office of General Counsel.
And I'm assuming that the board didn't even know about this, right? Because if the board didn't talk about it, it looked to somewhere else to figure out what a community college was, right?
You're right, Your Honor. They relied on Department of Education's definition of community college, which, based on this memo that was issued in June of 2011, Education Service was also relying on the Department of Education's determination of what was a community college.
And there's no question here, though, that this isn't a community college, right?
Correct.
No, I don't even think of how. So, does this memo that you're talking about matter at all?
Not particularly with respect to the language of the statute, Your Honor, and that is what we are looking at here, the statutory language, which limits.
Even on the basis, as I understand it, Mr. Lacey has never argued that the place he's going is a community college or technical.
Correct. He does not.
basically, it sounds like this memo simply said, hey, we've looked at the Department of Education's guidelines of what what a community college is, and we agree, basically.
Correct. Yes, Your Honor.
Okay.
So when looking at the legislative history, specifically the October 2011 House Veterans Affairs Committee report, the committee specifically noted that VRAP would allow veterans to enroll in courses at community colleges and technical schools, and that benefits would be payable for programs of education leading to an associate's degree, certificate, or similar qualification.
So, or, I mean, it strikes me that some of the quirkiness of the language here has to do with the small window in which this provision will be operative. I think it's 21 months or 20 months or something.
Yes,
So,
yes, Your Honor.
So a veteran would enroll at an institution, and then, because if they can enroll, right, let's say March 28th, that's right, and as long as the payment, that's right, they can then continue, even if that carried on beyond the March 31st date, it's just that they could make more payments, right?
Correct, Your Honor.
They would pay upfront or month to month, they would just pay for the full semester.
It was paid on a monthly basis, and veterans were required to certify their enrollment in the program of education at the approved school on that monthly basis in order to continue receiving the 12 months of benefits.
So for April and May, if you're just assuming kind of a normal spring semester, the veteran would have been responsible for paying the remaining month or two themselves.
With respect to the end date of the legislation in March of 2014, yeah. Yes. Yeah, what VA actually did, which again is not relevant to this case, but they determined that they could issue lump sum payments for veterans who were enrolled in programs of education that extended beyond that March 2014 date up to June 1st of 2014. So
that would explain that's what leads to language.
Yes.
It's possible the actual attainment of the degree would happen after that March 31st date.
Correct, Your Honor.
So the legislative history that you were discussing from the committee report,
Yes.
what do we do with it in the fact that it is consistent with both of your positions, right?
In that respect, Your Honor, what you would need to find, if the language is not ambiguous, is a clearly expressed legislative intent to the contrary. Here in the legislative history, there is no clearly expressed intent that four-year universities and bachelor's degrees should be included.
So I'm with you if what we said is, if I looked at this and I said, I agree with VA's reading of this entirely, let me check and see if that I'm crazy and look at the legislative history. Right, there's clearly nothing that would then point in the other direction. But let's assume that I'm the kind of person that's going to say, I'm going to look at legislative history to resolve what I see as an ambiguity in the language. In that case, arguably what you've read from the legislative history doesn't help me resolve the ambiguity because it's consistent with both of your positions, right? Because if you can get it at a four-year college, that still means you can get it at a two-year college, right? It doesn't exclude that, right? So if I'm not using legislative history only to say, hey, is it really pointing in another direction when I've determined it's really not ambiguous, but just to resolve ambiguity, it seems to me that there are things in the legislative history that just are consistent with both of your positions. And I don't know what we're supposed to do with that in terms of helping us with the ambiguity.
Yes, Your Honor. In that situation, I would advise that it's important to, again, review the statutory definition of program of education, which includes the predetermined and identified educational objective. And in this case, or in any case, a program of education with the predetermined objective of a bachelor's degree is not offered by a community college or technical school. Additionally, in the legislative history, in November of 2011, the House and Senate Veterans Affairs Committees issued a joint explanation of the legislation. With regard to VRAP, again, they explained that the benefit would be available to veterans enrolled in education or training programs at community colleges and technical schools.
Yeah, but that is not the language in the statute.
Correct, Your Honor. That is not the term is offered by, but again, that is describing the criteria needed to be met by the program of education.
Yes, but the key link then would be, is it the program of education that the veteran is enrolled in, right? I mean, that's what the missing language is, right? And I have no doubt, and I think Judge Cote may have said something like this, I have no doubt that everybody that was voting on this in Congress just was working under the assumption that most of these people were going to be getting their training at a vocational school or an associate's or a community college. Mm-hmm. But it's the connection between the idea that Congress used the term offered, but never connected it with any connection to the veteran being enrolled in the place that actually offered it at the place, right? And so where is the best place that you want me to look in a statutory language to find that connection?
Yes, Your Honor. There we would point you to the word pursue. Congress specifically said a veteran must pursue a program of education offered by a community college or technical school. If they are not pursuing a program offered by a community college or technical school, then again, they are not meeting the criteria outlined under the legislation to receive benefits.
So what would you say if what we had is a situation where you had associate's degree, okay, or you have a community college that offers, a program to do X, right? And it's all lined up. You have a curriculum that gets you to being trained for X, whatever that is. And a 4-year college, someplace that offers a 4-year degree, has exactly the same program. It's literally copied. Everything is exactly the same. So the veteran goes to the 4-year college. Right? He's not enrolled at the community college, but he is in a program that is offered by the community college because it is identical. Right? And so the argument you're saying is that pursue means he has to pursue at the place that qualifies as a community college. But it seems like we're adding words at that point.
I understand that, Your Honor, and with respect to whether a 4-year school in your hypothetical is offering the exact same program as a community college program, the same predetermined educational objective, we don't deny that would create some problems, but that's not what we have here. The Veterans Program of Education was not offered by a community college or technical school.
Well, now the board never found that, right? The board specifically says we're denying this because you didn't pursue this at a community college, right? And the board clearly got that wrong. At least by saying this language means you must be at a community college, right? Because it doesn't say that. Which I'm not sure the board ever made an equivalency determination, did they?
You're right, Your Honor. They only determined that the veteran was not attending a community college or technical school. Right. We argued that the term pursue inherently indicates that a veteran needs to be pursuing at pursuing a program of education offered by a community college. It needs to be at and enrolled at that school. Additionally, what's worth noting, while not necessarily indicative of congressional or legislative intent here, is a July 2011 House Veterans Affairs Committee hearing that was held on this legislation. The only verbal testimony that was provided at that hearing was from the president of Erie Community College. There was no written or verbal testimony provided by a representative from a 4-year school. The president of Erie Community College testified as to the benefits of a community college program versus a 4-year program. Those benefits included the low cost, convenience, and flexibility of such programs. Additionally, and arguably most importantly, community college programs could be adapted to take advantage of education and training a veteran had obtained during active service, with the goal of hopefully allowing a veteran to complete any additional education or training within the 12 months of VRAP benefits which they were allotted.
Didn't he also give testimony at that hearing that focused a great deal on the transferability of credits from 2-year colleges to 4-year colleges?
He did discuss that, yes, Your Honor. But when reading the hearing transcript and the questions presented by members of the House Veterans Affairs Committee, it is clear that their concern was whether or not a veteran would be able to take advantage of these skills in the training they learned in active service and apply those to additional education or training at a community college program, hopefully complete that program or that program of education within the 12 months allotted. There's sufficient or additional testimony provided as to different vocational programs the community colleges could offer, which could possibly be completed within 3 months, not even requiring a full 2 years for an associate's degree. And the goal of community colleges, which he testified to, was not necessarily on graduation or obtaining that associate's degree, but it was getting the practical training needed to enter the workforce, which is in line with the policy of VRAP to get veterans working in high-demand occupational fields quickly. So like the language of Section 211 itself, the legislative history is clear. Congress intended VRAP benefits to be used at community colleges and technical schools for the pursuit of associate's degrees, certificates, or similar qualifications. A clearly expressed legislative intent to the contrary, that 4-year universities or bachelor's degrees were meant to be included, cannot be shown. There are no further questions. For the reasons stated today and pled in the Secretary's brief, we ask that the Court affirm the Board's decision. Thank you.
There's a lot there. First, I'd like to address the Secretary's contention that Gardner shouldn't even apply here. The idea that the Secretary would not want a pro-veteran interpretation here just kind of took me back a little bit. This was the fact that the program was only available to 99 veterans means that for those 99 veterans, this was really important and a great tool. And this is a purpose of this was to get veterans into a retraining program. How is there a retraining if they don't have some sort of education to begin with? Second, the Secretary noted that there's nowhere in the record that Mr. Lacey was unemployed. The Secretary himself certified that. There's no way that Mr. Lacey could have been eligible for this program if he wasn't unemployed. So the fact that there was no specific statement, there doesn't need to be because he was certified for this program. Next, Judge.
This wasn't really a factor the Board looked at, but it was to begin his course of study after the July 1st, 2012. This is a requirement of the statute.
No, Your Honor, he did not. He actually started his program on his own earlier than the program was enacted, and then he went and spoke to a VA rep, not employee, but one of the school employees that deals with VA issues at a school to try to discuss with them how am I going to pay for this. At that point, he was just taking some online courses, and the employee at the school said there's a $10,000 scholarship that we can get you, and then there's this amazing program coming through called VRAP that you can take courses here and get that. So even the Medill College employee thought that Medill College met these qualifications. And that's somebody not within the VA itself. That's somebody that's just looking at the plain language here and saying, hey, wait, we offer programs of education that are also offered by the community college. So how do we get there? The Secretary wants to point out that an associate's degree and a bachelor's degree are not the same, and I think, Judge Allen, you pointed out too, that's obvious. They're not the same, but we're not looking for the same degree. What we're looking is similar evidence of completion of the program. And at the end of the day, if you have that degree that you can kind of hold up, that shows you completed the program. So whether it's the associate's degree or the bachelor's, the title of it shouldn't matter. What's important is that you went through and that the coursework that you were taking was going towards something at the end. Now, to the Secretary's point that the objective here for Mr. Lacey could never have been met at a four-year college because his objective was a bachelor's degree, I take issue with that. Mr. Lacey's objective for doing all of this, his professional objective, was to get a job. So whether he went through and got it through the getting another associate's degree or getting it through the bachelor's, his objective at the end of the day with doing this was to get work, to go back into the workforce and to become another, productive member of society.
I can interject, though. I think the Secretary, in all fairness, was pointing to the language in 3452B that defines the term, a program of education means any curriculum or combination of unit courses or subjects pursued in an educational institution, which is generally accepted as necessary to fulfill requirements for the attainment of a predetermined identified educational or vocational objective. So I think that's where they're using that term. So to expand it to get a job, yes, I think that might be the purpose of the statute, but that's not the 3452B language in the BRAP specific language.
I think, Your Honor, that you missed a word. I think it's an identified educational, professional, or vocational objective. And that's where you get in here, and that his professional objective is to be getting the job.
Everybody's objective?
Yes, Your Honor.
So I think specifically here might professional mean a different term of art, such as, I don't know, a professional, real estate agent or whatever they might mean by that, educational meaning a degree, vocational meaning trades, jobs, and professional meaning maybe a certificate or something.
It could, Your Honor, but I think, again, if you're looking at this with a broad intention of trying to get veterans back into the workforce, and your purpose, Mr. Lacey, was looking for, his objective here is to get a job. The bachelor's degree is just happenstance. That's the tool to get him the job.
But you don't have to win on what you're talking to Judge Sheldon about right now, right?
No, Your Honor.
I mean, because it seems to me Judge Sheldon's definition is referenced from Part B there. It describes the end of the road being an associate's degree, but it also describes the end of the road being a bachelor's degree. I'm not sure that answers the question necessarily, right?
I agree, Your Honor.
Well, the second part of my question was going to relate to the Secretary's argument, was if you describe, or if you infer the BRAP beginning language as describing a program of education as opposed to what the veteran is doing himself, as they described, and they limit the types of programs that can be to community college offered programs, and then relate that back to what is offered at a community college as an associate degree. That's the part that I'm trying to understand. If they read this limiting language to be only associate degrees or technical degrees, technical certificates are eligible based on these are the only program objectives that are offered at these institutions. A bachelor's degree is not that. How do we get your guy into that bucket?
I think, Your Honor, we get there by the parenthetical, which is the only way that we're actually here to begin with. If the parenthetical or similar evidence of completion of a program of education wasn't there, the Secretary is right, we wouldn't be here. If it only allowed for the associate's degree or certificate, then Mr. Lacey couldn't be here. But that parenthetical...
But you don't get to 3 until you've gone through 2. And 2 is offered by a community college. So getting back to her argument of the only things offered at a community college or technical program are an associate degree or certificate. You don't get to, or the similar part.
Well, Your Honor, I'd say that information is actually wrong. You can go to community college and not looking for either. Community colleges don't only offer those degrees. They also just offer an opportunity for students to be taking coursework that will eventually, as Judge Allen noted earlier, be transferred to a four-year college. So that's not the only things that are offered by a community college or technical school. Those are just happens to be some sort of establishment of a completion of the program. And again, it's leads to these. It's not that you have to have completed any of this. And most veterans that actually took part in the program, as the Office of Inspector General pointed out, didn't even complete any of these degrees. They just took the 12 months of credits and went on their day. Mr. Lacey, however, not only did he complete his degree, but he graduated in the top of his class and went on and got the job. And the secretary was talking about the greatness of community colleges and the specific testimony by the president of Erie Community College. That's great, and the community colleges are wonderful. My husband actually teaches that one. This is not to say that the same type of programs can't be offered at four-year colleges such as Medill. In fact, that's specifically why he went to Medill College, was that they have relationships with members of the community, and were doing this same sort of thing. He was recruited from a firm that has specific relations with Medill College, and that's where he went on and worked once he graduated. So the fact that the secretary is now trying to say veterans like Mr. Lacey weren't intended here, I think veterans like Mr. Lacey is exactly what was intended here. It was somebody that was in this age group, and they're looking for retraining, and that has to mean something, right? The idea that they're not just coming in and trying to use the Army skills that they had, but also to this age group. Well, this age group, a lot of them probably went to school to begin with. And so that wasn't enough. That's not enough to be getting them jobs. And so the whole purpose of this is to get these guys in this age group back, and girls, back into the workforce. We're trying to do a retraining. We're trying to get them out there. So based on all of this Mr. Lacey would have you go back and say that the board's decision was wrong. You should reverse its finding that his program of education should not be entitled to VRAP benefits because Medill College offers programs similar to what a community college or technical school does, and that he ordered the secretary to pay him for his 12-month worth of benefits that he should have received for his coursework at Medill College. Thank you.
The case will be submitted for decision. The court is now adjourned. We will have